Okay, great. Thanks for that introduction, Sue. And well, thank you very much to you all, firstly, for dragging yourself away from some really quite glorious sunshine today and indoors in front of a screen. So much appreciated. I shall do all that I can to keep this brief and to the point for you. But as we're such a small group, I'm hoping that if we have any questions come up as I'm going through these slides, please feel free to interrupt and ask those questions, because I think that will make this a much better discussion if you say what's on your mind. Maria, you were interested in learning about IP. The topic is vast. Today we are going to be focusing on quite a specific area, but a recent change in the law, which is this new thing called the Unitary Patent. Obviously, those of us in IP are aware of this to various degrees, but what I'm hoping to talk through with the rest of you is sort of the strategic considerations that arise out of this, which reach further than just IP and patents, so that you can hopefully understand how this might actually be relevant to your practice, to your clients' businesses, as we get to grips with this brand new piece of legislation. So why on earth am I qualified to talk about the Unitary Patent to you? Well, I'm a patent attorney at JA Kemp. As many people have mentioned already today, we're one of the largest European and UK patent and trademark attorney firms. So we're all UK and European patent attorneys. We've got offices in the UK and in Europe. We're ranked in tier 1. So without wishing to toot our own horn too much, we're pretty good. As I think is quite well illustrated by having Capil here today, because we're a big firm, we have got expertise all over the place. So we've got people like Capil in the bio team who deal with enzymes, which are frankly quite alarming to me. We've got people who can deal with software. Whatever the area of technology is, we've got somebody who can help. So that's one of the sort of major advantages with working with a big firm like us. The other thing that we have, which is going to be useful for us today, is quite a lot of resource to devote to these new legal developments like the Unitary Patent. And if there's anything that comes up today that makes you think, oh, I would like to know a bit more about that, I would point you to our website. We've got some introductory webinars, which I think are quite accessible, and which will talk you through this particular topic with lots of written guides as well. And Maria, if there's any other questions, there's an awful lot of material on there if there's any topic that you'd like to look at. But of course, if you don't find what you're looking at on the website, we're very happy to talk. Just get in touch by email, by phone, whatever. So the Unitary Patent, I'm going to not assume, because obviously we're not all patent attorneys here, we're not all legal people, I'm not going to assume that we know what it is. So I'm just going to briefly talk you through the system that we're working with at the moment, what changes with this new Unitary Patent, and then what new strategy considerations we and our clients will have going forward, and what we might need to do in view of those new considerations. So the current system, what do we do now? This is a European system, and at the moment what we have is a European patent office where if your client, a scientist, has an invention, you can apply to the European Patent Office for a patent, and you will have some discussion with them about the scope of your invention and the scope of your patent application, and then you will reach an agreed scope, an agreed form of words that the European office will allow. But at that point, there is no such thing currently as a Europe-wide right. So you take your allowed patent, allowed by the EPO, and you will then validate it in the countries of interest. So there are lots of participating member states in the EPO. European is a bit of a misnomer, really, because in addition to EU member states, we've got the UK, we've got Switzerland, and we've got some slightly more interesting countries in there like Turkey. You take that agreed allowed scope of patent and then you validate in the countries of interest. So what you get at the moment is a bundle of entirely separate national rights, which are completely independent, although they will have the same scope. So for instance, if I had a European patent that was granted and I validated it in Germany and I thought that Sue was infringing my patent in Germany, I would go to the German court. I would bring an infringement action against Sue. she might claim that my German patent was invalid, and we would argue about that in Germany. The German court would reach a conclusion, and then I might have, say, a different scope of German patent or something. We would end up with a conclusion for Germany and Germany alone. And the other patents, my other validated patents, would be independent of that. Now we have a unitary patent. So a lot of things stay the same. Everything which happens up to the allowance stage is completely unchanged. We go through exactly the same procedure. And for all of the countries which are not participating in this new unitary patent, actually at grant and after grant, everything stays the same as well. So the non-EU member states, including now the UK, Switzerland, as I mentioned, Turkey is another example. You can't get a unitary patent, so we will do exactly the same as we did before. You validate your European patent in those countries, and you pay your annual renewal fees individually in each of those to keep that in force. For the other countries which are participating, it's important to remember that actually that traditional route will still stay as an option. You can keep your practice entirely unchanged if you want to. However, we have this brand new option. For all participating countries, and I've listed the current ones at the bottom there, in the last couple of days, actually, we've added Ireland. Instead of going to the individual countries and validating your individual European patents in each of those separate states, you can now apply for a single brand new right, a unitary patent, which is a right covering all of those participating countries. That's obviously not going to be a national right. So if I wanted to enforce my unitary patent against Sue, for instance, I wouldn't be able to go to the German national courts to do that because it's not a German right. So in addition to this brand new right that we have, we're going to have a brand new court, which is going to deal with all of the questions, all of the litigation points, revocation of unitary patents, infringement of unitary patents going forwards. So it's quite uncharted territory, really. It's not very often that you get a brand new court set up, and the case law obviously is completely unsettled. We've got no guidance yet, apart from just the rules and the regulations telling us how this is going to work. So quite interesting. Just a brief note at this point about the participating countries. There's a nice colourful slide here which will talk you through the relevant states. Everything that's in purple in this slide, and I hope we haven't got anybody who's colourblind, but everything which is in purple here is a state which is going to participate in the unitary patent. So if you get a unitary patent, it will cover immediately or ultimately all of these purple states. So you can see that's quite a lot of territory. There's big countries in there, obviously the major ones, Germany, France, Italy, Ireland recently signed up. You're going to cover quite a lot of people and quite a lot of territory with this single right. There are some EU countries who haven't yet agreed to join, and the big one to mention there is Spain, that's shown in blue, but in due course we're expecting that they will probably come round and join up. But of course there are lots of countries who aren't EU member states and who will never be eligible to sign up to the unitary patent. That's us now, Iceland, Turkey. There's a few other countries in there. So the unitary patent doesn't replace the traditional route. We are always going to end up with traditional validations in some cases, but we do have this brand new option available to us. So that's the technical stuff dealt with, gone. Keep it vaguely in mind, but now we're going to consider the slightly more interesting question of what does that mean for industry, not only for us in the patent profession, but also for business more widely. I'm going to talk through some of these points in more detail in just a second, but the main thing that we want to do is to weigh up for all of our clients, is this something that we should do, or is this something that we should not do? Do the advantages of a unitary patent for us outweigh any potential disadvantages? The main things to think about on the advantage front is going to be, for patentees, cost. It's going to be hugely cheaper to go for this single new right, which covers 17 or more states, rather than individual rights in all of those states. And there are also brand new opportunities that come with this new court. So new opportunities to attack your competitors' patents via a brand new court, and new opportunities to enforce your own rights centrally. So rather than, say you had a patent that you wanted to enforce against competitors in France and in Germany and in Italy, rather than going after somebody in each of those individual countries, you can now bring a central action covering all of those activities in all of those countries under your central unitary patent. And this system is going to be designed to be quite an attractive option for litigants. It's intended to be a very rapid, very streamlined procedure, to be completed within 12 months, whatever the complaint. And I don't know if you've had any contact with, well, Patricia certainly will have had lots of contact with IP litigation, probably far more than she cares to mention, but 12 months is pretty quick. You're going to get certainty pretty quickly, and that will set the tone for further settlement negotiations, for discussions with your competitors worldwide. There are potential advantages to using this system, especially if you want to attack other people. The flip side is, of course, there are disadvantages. This brand new court is new and untested for us. We don't know how this conglomeration of all of the national laws, the judges drawn from all of these different member states, how that will work out when it comes to the finer points of infringement and validity discussions. So there is going to be more uncertainty about whether a unitary patent is valid as opposed to a traditional UK patent, for instance, or a traditional German patent where we've got fixed case law and we've got a reasonably good idea of how judges will find on it. There's also the point that if you have a single patent, all your eggs are in one basket. So it used to be the case that if you went for the traditional route and the German court made the wrong decision on your patent, you would at least still have France, you would have Italy, you would have plenty of other countries. So one wrong decision wasn't too much of a problem. Whereas now, of course, everything stands or falls centrally. The other disadvantage to bear in mind is that the flip side of having this rapid and streamlined new litigation procedure is if you have a patent and you receive, say, an invalidity action, you've got very little time to respond. So somebody could have spent months and months and months crafting an attack against your patent. It's served on you, and then you might have 3 months absolute maximum to come up with a reply, which is not very long in patent terms, especially if you've got a big team that you need to coordinate and think about what's going on worldwide. And because of these risks, there is a possibility that these new unitary patents, at least initially, are going to be less attractive to potential acquirers of a business than traditional patents. So if you are a spin out, if your exit strategy involves being bought up, there is a lot to be weighed between the cost savings and the potential disadvantages of this brand new route. There's just a couple of points there that I wanted to pick up on in slightly more detail, because one of them is cost. So anybody who has got a fairly widely validated European patent will know that that's quite a costly procedure. You pay renewal fees in every country, and then you'll pay a fee on each of those to your renewal service provider for monitoring those renewal fees, getting your instructions, paying them. It's a big cost. A unitary patent will give you the equivalent of sort of 17 countries worth of protection for about 4 renewal fees. That's the level that the fees are going to be set at, roughly 4 national fees. And of course, you'll only be paying a single service fee. So if we are preparing budgets for our clients, we've got anybody who's got a finger in an accounting pie maybe, or a cost planning pie, a budgeting pie, this could be a big change in the IP costs for European clients. And obviously the one thing that we might want to think about if we're slightly further removed from the patent side of things is, well, if we can cut costs in a big way going forwards in European patents, what does that free up cash for us to be able to do? You know, maybe, Andy, maybe some more video marketing, maybe Jeff some more IT infrastructure projects. There is going to be a significant consideration for companies who are currently spending a lot of money on European renewal fees. Enforcement opportunities, again, this is at this point in time when the court hasn't been set up, it's quite hard for us to think seriously about this, but it is something that we need to be prepared for, because when this court comes into being, which could be in a few months' time, I'll talk a little bit about the timeline in a couple of slides. From day one, you will be able to bring a revocation action against one of your competitors' patents if you want to get rid of it. You will be able to, well, you will certainly have the possibility of being on the receiving end of an infringement action, an invalidity action. And so we need to have thought about whether you want to do that, prepare it, bring any actions on day one, and what will happen if you are on the receiving end of something on day one. As I've said, this is going to be a very quick procedure. And so if you're a patentee and you've got a problematic competitor, then under a unitary patent, you've got some advantages. You can get resolution quite quickly, and you potentially also can prove infringement a little bit more easily. We see this quite commonly with patents which are directed to sort of multiple step processes. If I had a patent to a process, software is a typical example of this. You might have a software patent which has got a number of different steps in the process that you're claiming, and one might be carried out on a server in the UK, one might be carried out on a server in France, and then the end user might be in Germany. You know, you may well have something which is a process occurring across borders, and traditionally it's quite hard to prove infringement of that. And stop your competitors doing that because they've separated out what they're doing across borders. But there is quite a strong argument that under the UPC, anything which is done within any of the contracting states to the UPC, and possibly even within the EEA, provided that the whole process takes place within that much broader territory, you can still prove infringement. So you may be able to enforce against you may be able to bring enforcement actions against people who you previously wouldn't have been able to under this new court, under this new right. So that is something to bear in mind. It potentially seems like quite a niche possibility at this point, but I think once we are up and running with this, we will start to see how the possibilities pop up for our clients, and see the new opportunities there. The other important point to bear in mind is that I'm talking about this new right, this new unitary patent, but this new court is backwards compatible. What that means is if you have any European patents right now, which are granted and validated in any of these UPC contracting states, France, Germany, Italy, among others, then unless you opt those patents out of the new system, this brand new unitary patent court will have jurisdiction over those existing granted patents. So you might be thinking, well, I'm not going to get unitary patents. I've got my existing European patent. I don't need to worry about this court. But actually, if you don't do anything and somebody brings an action against you, they might bring a revocation action, for instance, against one of your validated patents, you will have to deal with the UPC, whether you like it or not. So it's important to think about whether you've got any patents which are at risk of this, and equally whether you'd like to enforce those patents via the UPC, even though they may not necessarily be unitary patents because they haven't started being granted yet. So the sort of take-home message is think about your own strategy in terms of patenting and your competitors' strategy in terms of patenting. Keep an eye on what they're doing, because we need to know what we're going to do if these actions are brought. The other sort of central concern that I wanted to mention is we've talked about cost and what this is going to do to our clients' costs. We've talked about enforcement and the risks which are potentially going to pop up with these brand new rights. Another major area which is going to change quite subtly is freedom to operate. Now, generally, whatever we do, we're relying on the fact that we're not infringing other people's patents by doing what we do. But it is now going to be easier for our competitors to obtain broader European patent protection because it's going to be much cheaper for them. So if our competitors have previously only validated their patents in certain countries and we've relied on the fact that we're not based in one of those countries, our competitors' strategy might change going forward. You know, some of this capital which is freed up might be being used to broaden their protection. So we need to keep an eye on our competitors' breadth of protection and to keep an eye on our own freedom to operate. And of course, the other thing to bear in mind in terms of freedom to operate is that with this brand new court, this cheaper, streamlined litigation, previously, if a competitor had a patent that they'd sort of decided not to enforce against us, and we had sort of thought that we might be getting away with something there, there is now a sort of quicker and cheaper route for competitors to take that patent and do something about our slightly shady activities. So things which we thought might not have been a problem previously could be becoming a problem. So again, we need to think before this all starts kicking off, when the UPC comes into force, are there any patents that we're at risk of? What are our competitors doing? Are there any patents that they might enforce against us? And equally, are there any patents that we have that we suddenly think that we could use against our competitors to try and knock out somebody who's a bit of a problem? So again, the central message from this slide is really monitor your own activities and your competitors' activities to work out what your strategy is going to be under the UPC. Is it an opportunity that we can use? So finally, the timetable. What we can do immediately is to look at our own patent portfolios, our client patent portfolios, work out what cases we want to opt out of the system, anything that we have already. And we're also going to want to work out our policy, our tactic going forward. Do we want a unitary patent? Do we want that for all of our patent applications? Not only from a patent point of view, also from a budgeting point of view. What fees do we want to pay going forwards? What is our financial strategy going forwards in view of this new potential cost-saving procedure, really? The unitary patent will come into being when Germany ratifies the agreement, and then that's originally scheduled for July 2022. And as you know, we're rapidly running out of July 2022. So it's looking quite likely that that timetable will slip a bit, but it's expected to be sometime over the summer or possibly early autumn. Once they ratify that, we will have a sunrise period of 4 months in which we can actually start to do things. We can file opt-outs for our existing patents, and we can start to delay grant of any European patent applications that we want to turn into unitary patents. We should also, during that period, definitely keep an eye on what our competitors are doing. Are they opting out? Are they not opting out? Are they delaying grant of patents? What is their strategy likely to be, and how will it affect us? And then finally, again, this could happen as early as October 2022, but it's more likely to be spring 2023. The UPC will come into force. And then from day one, we can start to litigate at the UPC, and we can validate European patent applications as unitary patents rather than our bundles of national rights, if we want to do so. Okay, that was a lot of information. I hope that we can look at these questions that I put up here to think about what that might mean for us as legal professionals, as potential patent holders, as advisors to patent holders. Do a bit of thinking really about what we what impact this big change is going to have, because it is a big change. I know it might seem a bit distant if we're not directly involved in patents right now, but it really will have an impact. So I've put up a couple of situations here, and we can think about which one we might want to talk about. One situation, we'll call them client A. What about this one? A brand new startup. We've got two friends just out of university. That's all they've got. They've got a bedroom, and they're seeking investment for a new company because they've got an idea. They've got a revolutionary new medical device, potentially a syringe for vaccine delivery, something quite topical. They've got a European application, but just the one, very early stage. What should they be doing? Should they be thinking about unitary patent protection? And what should they be worrying about? If we also look at client B, somebody a bit further along the procedure, somebody who's a bit bigger, by way of example, I've suggested that they're developing some new screens. They've got a mid-sized portfolio, so they've got a bunch of different European patents. They've got some pending applications. They've got a brand new technology, but it's a competitive area, and they're looking for funds for a big new manufacturing plant. So I'll leave these up, I think, but I wonder if the fairest thing to do might be to throw this open, possibly ask the legal professionals first if they've got any